Tom, thank you. That was a great overview. And if you think it's hard to garner public sympathy for Pfizer, you should look at how the public feels about insurance companies. Insurance companies are the pariah of the financial services industry, but Montana is among the worst states for insurance contract law, and I think that's something that the more common scenario, like the one that Tom outlined in the parking lot slip and fall case, the more common scenario that you see in commercial insurance is companies wanting to avoid any publicity and settle immediately, regardless of whether there's any actual culpability. And just 2 seconds on a scenario, because this happens all too often, and Montana businesses and Montana consumers pay for this. This dynamic and the difference between Montana and other states is not free, and it's not subsidized by other states. It's paid for by Montana consumers. But if you have a $5 million policy, for example, and there is a suit brought against a commercial insurance client, and there's general agreement between the insurer and the client that there was no wrong done, there was no actual culpability. The demand is for policy limits, and they have a $60 million demand, but they say, give me your policy limits. And the client says, tender the policy limits. I don't want to be involved in this from a publicity perspective. And the insurer says, that's crazy. We're in agreement that you did nothing wrong. If the insurer does not tender that $5 million policy, then the insurer uncaps its limits, and the insurer owns everything above that itself. So if they take a flyer and get the $60 million, the insurer's on the hook for the entire $60 million. Montana's not the only state where that's the case, but it's one of a few states where that's the case. And so there's a lot of work to be done, and this is real world stuff that translates straight down to the business in Montana and the consumer in Montana. So thank you, Tom, for that great overview. So next up we have Lee Mickus, and Lee has been in Denver where he's based, and he is with Taylor Anderson. Lee defends manufacturers in product liability and tort lawsuits all around the country, not just in Colorado. Lee has testified before the state legislature on bills affecting a wide range of civil justice issues, including product liability, punitive and compensatory damages, prejudgment interest, and procedural matters. Lee was president of the Colorado Civil Justice League in 2009 and 10, and currently serves on the board and on the legal advisory board of that great organization. Please join me in welcoming Lee to Helena.
Well, thank you so much for that introduction, and as a former West High Bear, it is terrific to be back in the state. Thanks so much to Bridger and to Webb for inviting me. When we started to speak about what I'm going to talk about, an issue that Amy actually raised came to the forefront, and that is, what can we talk about, what can we put on the agenda that is a concrete, practical step that can be taken to maybe work on Montana's ranking in that ILR system? What can we do to maybe step things up and improve the litigation climate within the state? But before we get into the nitty-gritty, I want to maybe take a little bit of an audience participation survey. So on your way here to the conference, who wore their seatbelt? Just a quick show of hands. Hey, that's great, almost everybody. Well, you're in good company. These are national statistics, but nationally, about 90% of people habitually wear their seatbelts. That's a change from the mid-1980s, and as you can see, the Texas Supreme Court, in a recent decision, recognized that change, that attitudes are different today about seatbelts than they were back in the 1980s. So let's go back to my survey. Who thinks seatbelts make a difference to crash outcomes? All right, just about everybody. That's great. Well, there's a good reason for that, and you're in good company in thinking that. The National Highway Traffic Safety Administration has done a ton of research, as you can imagine, on this issue, and the results are pretty consistent, that somewhere between 45 and 60% of fatalities and major injuries would be prevented or reduced if people wore their seat belts. And in fact, those national statistics are probably a little bit low for what it would translate to in Montana, because here, with more rural roads, higher speed limits, more pickup and SUV use, you see an even greater effect. And interestingly, when you look specifically at what the Montana Department of Transportation says, they attribute about two-thirds, 68% of the fatalities in 2015 were attributed to not wearing a seatbelt. So in terms of the accident outcomes, seems pretty clear, seems pretty well established. Seatbelts make a difference. But it doesn't just make a difference in terms of the accident outcome, it makes a difference in terms of the financial outcome as well. A financial outcome that hits all of us from Montana in their pockets. Because it's not just the people who are injured and suffer a greater degree of injury severity that are paying for those costs. In fact, everybody pays for it in terms of higher health insurance, higher property and casualty insurance, and maybe more directly in terms of taxpayer-funded programs. It hits everybody. So it's not just a difference in the outcome of that crash, it's a difference in the outcome of your expenses. That's a big difference. Now let me ask the last question in my audience survey. Who thinks that juries get to consider seatbelt non-usage when they look at a car crash case? Who thinks that? You guys saw the punchline. That's too bad. Under Montana statute that has been in place since 1987, that evidence, the fact that somebody was not wearing their seatbelt in a car crash, does not get considered by a jury. So think about that as a policy level. We have a Department of Transportation within the state that is spending hundreds of thousands, maybe millions of dollars to promote seatbelt use, to make people think about seatbelts every time they get inside their vehicle. But then, after receiving all of that wonderful education and hearing about all of the effectiveness of seatbelts as an accident mitigation tool, all of those citizens are asked to put all of that information completely out of their mind when they step through the courthouse door and sit on a jury. Is that a good, consistent policy? I'm not sure. Let me bring it home with a very specific example. This is an actual case that I worked on in my product liability practice. It was filed here in federal court over in Billings a few years ago. This is an actual piece of an article out of the Bozeman Daily Chronicle documenting what happened to a very unfortunate person by the name of Gina Erickson. She and her boyfriend were out at a kegger in the middle of the night on a mountain road outside of Belgrade. They apparently hit the bottom of the keg and decided the party was over. They got on a narrow, windy, dark mountain road, and Gina made the unfortunate suggestion to her boyfriend who was driving, "Why don't you change the radio?" He reached over, took his eyes off the road, rolled his Bronco 2 down a hillside. It rolled 4 times. She was pitched outside the vehicle and killed. She wasn't wearing her seatbelt. Horribly tragic accident. We can all agree on that. Would seatbelts have made a difference? Well, probably. Fast forward to the lawsuit. Her family sued Ford Motor Company because clearly that was the vehicle's fault for the crash, alleging that there was a defect in the composition of the side windows, and the side windows should have been the restraint system on the vehicle. In a crashworthiness case, Ford's attorneys, including myself, took that to the court and said, surely the jury ought to be allowed to consider seatbelt usage in a product liability claim, arguing that it was the car's inability to protect the occupant, that the jury ought to be allowed to consider the fact that Ms. Erickson chose not to use the primary occupant protection system in the vehicle, her seatbelt. Based on that statute that you took a look at earlier, the federal court, this was Judge Osby, her hands were tied. As you can see, Montana law is clear that evidence of seatbelt usage or non-usage is not admissible in civil actions for personal injury sustained in a motor vehicle accident. That's any kind of motor vehicle accident. Product liability against the state, against a tire company, you name it, it's out. It cannot be considered. Well, why should all of us in this room care? You know, this is really just an insurance issue, isn't it? Maybe auto manufacturers. It's pretty narrow. Well, the real answer is no, because directly or indirectly, everybody who pays insurance and anybody who has exposure to the transportation industry faces some of the higher costs that go along with this statutorily induced problem. That's railroads, that's auto dealerships, that's home service providers like electricians and plumbers, that's small businesses, that's everybody. Everybody picks up the cost for these increased insurance premiums and increased government programs. So let's dive into why would it be a good idea to move away from Montana's gag rule, as I like to call it? Well, first, as we've seen, Montana citizens expect people to wear their seatbelts. 75% of Montanans on a regular basis are buckling their own seatbelts. That's a pretty clear majority. That's a pretty clear statement that we think seatbelts are a good idea. We also have the mandatory use law. It's a secondary enforcement in this state, but it is nonetheless a requirement that people wear their seatbelts. And that law is subject to police enforcement. If you're pulled over for another reason and you're not wearing your seatbelt, the police are going to write a ticket, and that's appropriate and fair, and it raises an expectation among Montana citizens that people should be wearing their seatbelt. Why else should we move away from the gag rule? Well, it rewards risky conduct. It encourages people to not wear their seatbelt and impose the costs of their risky behavior on others. And we talked a little bit about that. And then finally, and this is going to be some interesting discussion that we'll get into in just a moment, this gag rule has been in place since 1987. It is a product of an outdated political circumstance that was unique to the 1980s that doesn't exist anymore. And now, as legal constructs have changed, as that political situation fades into the rearview mirror, it makes sense to recognize what 75% of Montana citizens recognize, that wearing seatbelts is a good idea. So let's talk about that 1980s situation. And you're asking yourself, why on earth am I looking at Cyndi Lauper? What does she have to do with any of this? Girls just want to have fun. You're all thinking, rightly so, she's an icon of the 1980s. Well, so is this seatbelt statute. This came out of a circumstance that was unique to the 1980s. At that point in time, our country was facing this situation. The seatbelt usage rate in the country was around 14%. In Montana, it was even lower. It was in the single digits. And it wasn't changing. Promotional campaigns weren't making any difference. And the U.S. was unique. Other countries within the world had a higher usage rate. But within the U.S., it was seen as a state issue. It was something that saw some pushback from the courts because of the contributory as opposed to comparative negligence scheme, where if somebody was allocated even 1% of fault for an accident, then they could recover nothing. And maybe most importantly, airbags were seen as the great salvation that was coming. Once we get airbags in cars, there would never be another injury, so we don't need to worry about that. That was the scenario that was playing out in the 1980s. So enter our federal government, and then Secretary of Transportation Elizabeth Dole. The federal government had a great idea, and that great idea was this. They were going to throw the issue to the states. And they were going to force state legislatures during a period of time in the mid-1980s to take up this issue. And the incentive was this: if enough states, states representing two-thirds of the population, enacted mandatory use laws with certain specific requirements by a certain point in time, then they would not mandate airbags. But if not enough states enacted those mandatory use laws with all of those certain specific requirements, then airbags would be mandated and all new cars would have them, and they would probably be more expensive. Now, a key aspect of those certain specific requirements was that the mandatory use law had to allow seatbelt non-usage evidence to be admissible in court. So they threw this issue to the states. And starting in 1984, almost every state legislature considered the issue. And between 1984 and 1987, 31 states enacted mandatory use laws. But they also had their own agenda. Remember, people wanted airbags, and so they wanted to force the feds to require airbags to be produced as part of safety technology with new vehicles. So in order to make sure that the mandatory use law enacted did not count against that federal government total, they tweaked some of those necessary specifics. And one of those was this admissibility of seatbelt function. It was also seen, as the states debated it, that seatbelts were really a personal liberty issue. This is my choice, this is my car, this is my body. I'm not going to let Elizabeth Dole tell me what to do in that. So after all of that, a huge proportion of states enacted mandatory use laws that specifically disallowed seatbelt evidence from being considered, and Montana was one of them. All right, bizarre situation from the 1980s. How does it play out? Well, it plays out that this two-thirds criteria is not met. Airbags get mandated as required equipment for all new cars starting in 1998, and most of them were already starting to roll them out much before that. So this political scenario from the 1980s happens, and now it's in the rearview mirror. But here in 2018, we still have this statute that is residual from this 1980s circumstance. That's why you were looking at Cyndi Lauper, because this bill, this law, just like Cyndi Lauper, is an icon of the 1980s, and just like she's maybe no longer in fashion, and you don't see outfits like that anymore, this law is likewise an outmoded, out-of-date circumstance. What were some of the other factors that justified the existence of this gag rule at that time? Well, first off, and I mentioned this earlier, most states, including Montana at the time, had what was called contributory negligence. So if the plaintiff was allocated even 1% at fault, then that plaintiff couldn't recover anything. And a lot of courts and a lot of people thought that that's a pretty harsh rule. If I'm sitting at a stop sign and I get hit by a drunk driver and I don't happen to wear my seatbelt, I get nothing out of that. Boy, that's a pretty harsh outcome. Okay, that's a fair consideration. Another thought that was floated around is that it's really kind of hard to tell if somebody's wearing their seatbelt or not. How do you know? And maybe this is going to degenerate into a battle of experts, and you got to have people with a lot of background in engineering, and that's going to make litigation much more expensive. And then a third issue was really questioning the ability of jurors. Can they really make a differentiation between the kinds of injuries that would happen if somebody had been wearing their seatbelt? If there was going to be a crash anyway, presumably there'd be some sort of injury. So can we really trust 12 people off the street to make that sort of determination? So those were some of the factors in place, and let's take a look at each of those and see if they're still in place. Well, the first one, contributory negligence. That was a harsh rule, but that harsh rule is now in the rearview mirror, just like the political situation that led to the statute in the first place. Montana has dropped comparative negligence and has now moved to a modified comparative fault rule. So long as the plaintiff is not more than 50% at fault, then the plaintiff can recover proportionately. To quote from the statute itself, contributory negligence does not bar recovery if it was not greater than the combined negligence of the defendants. So that harsh outcome no longer exists. We don't need to worry about that guy who's sitting at the stop sign who gets hit by the drunk driver. The jury can weigh the fault accordingly and allocate the fault accordingly, and the plaintiff can recover if that fault was not that extreme. What about that second issue? That it's really kind of hard to tell if somebody was wearing their seatbelt or not wearing their seatbelt. Well, since the time that the law was enacted, the car itself has started to integrate technology. As of late 90s and certainly by the early 2000s, all of the cars that you're driving have something called an EDR. Or an RCM, a restraints control module, or an electronic data recorder. There are channels in those devices that will allow, and recently there's been a federal motor vehicle safety standard that requires that they detect and record whether somebody is wearing their seatbelt. It's a simple matter of downloading those systems in order to find out a clear-cut answer. And I will also tell you that it's really not that hard to tell just from looking at the hardware. There are marks that get left if somebody is wearing their seatbelt, and those marks don't get left if somebody is not. But regardless, the car itself is going to tell you and give the answer to that. Well, how about that third reason, that juries really aren't capable of differentiating between injuries? Well, that's sort of an interesting line in light of what Montana juries have been doing since the 1970s. I talked earlier about the Erickson case. That was a crashworthiness case brought against an auto manufacturer. Sometimes it's called a second collision doctrine case. And what that means is that the plaintiffs are alleging that the auto manufacturer ought to have worked a little bit harder to provide a protection system to guard against injuries in a crash. And when those claims get made, the plaintiffs are conceding that the car didn't cause the crash, but the car could have done a better job and reduced the injuries. Those cases have been around in this state since the 70s. Jurors are being charged in those cases with doing exactly what they would be charged with if seatbelt evidence was admitted. That is, differentiating between what happens under the crash as it happened versus what sort of injuries would have occurred if the different technology had been in place, a different airbag or something like that. Here, we're talking about seatbelts. Juries are already doing it. The state already trusts juries to make that determination, so why would we not trust them with seatbelt evidence? Okay, so those are the reasons that were raised in the past to justify the gag rule. What are the reasons that are being raised now? And I will tell you, in the last legislative session, there was actually a bill to repeal the gag rule. It was Senator Fitzpatrick's bill, Senate Bill 259. And what sort of things did we hear about that? Both in the legislature and publicly? Well, some of the reasons that have been floated are it's better to be thrown free of the accident, so we shouldn't be thinking about seatbelts anyway. We hear that seatbelts don't really help much, and sometimes they even hurt people, so we really ought not to put seatbelts in play. We get that old libertarian element that it's my choice, not the doggone government, so keep out of my car. And then the last one generally is, well, you're blaming the victim, and we shouldn't be doing that. This is really all about who caused the accident. So let's take a look at each of those in turn. This one's my favorite. It's better to be thrown free of the vehicle. Yeah, I think this is probably better addressed by looking than me throwing out some statistics. So let's take a look at a few crash tests. This is a Volvo XC90 in a rollover. The dummies in this vehicle are not wearing seatbelts. So ask yourself, is it better to be thrown free of the vehicle? Ouch. So we've got some ejections, we've got some partial ejections, pretty violent wreck. This is about 35 miles an hour, if I recall correctly. I'm thinking it's maybe not so great to be thrown free, but you might be thinking, well, that's just one test. So let's take a look at another one. This one's a little bit bigger. It's a Ford Expedition vehicle. So there are 6 dummies in this vehicle that are not wearing their seat belts. This first one is in real time. Ouch. So now let's take a look at it in high-speed film so you can see in a little bit greater detail how the ejections work and where folks go. I like to call that guy Bob. Now, I don't know where he ends up, but keep an eye to see if you see him re-enter the camera frame. That's the windshield, that's not Bob. I didn't see Bob. We'll take one more look at this test run from a different camera angle down the track. There goes Bob. Wait for it. Where is he? Oh, here he comes. It's better to be thrown free? Well, let's make a fair comparison. So here's another vehicle in a similar dolly rollover test with belted occupants. This camera angle focuses on the left rear. You can see that there's a driver position, and as the video progresses, you'll see the driver and the front passenger are all in there. They're all wearing belts, and this vehicle also has side curtain airbags, but that's not to prevent ejection. It's just a cushion. There's some movement. You can see our driver is belted in the driver's seat behind the steering wheel. I think maybe you get the point. Is it better to be thrown free of the vehicle? Boy, I sure don't think so. And in fact, what the statistics show is that if someone is ejected from a vehicle in a rollover or in a high-speed wreck, they are much more likely to be severely injured or killed. I think the figure is something like 7 times more likely to suffer an egregious injury. So let's go to the next issue next pushback that we heard, that seat belts don't help much and often they hurt people. Now, you may say that's just a silly thing to say. I will tell you, when this kind of reform legislation was proposed last year in Missouri, a colleague of mine testified in front of the Missouri Senate Judiciary Committee, and the Senate Judiciary Chairman made this comment. Seat belts don't help much, and a lot of times they hurt people. Okay, well, let's take a look at that. Fortunately, the Montana Department of Transportation has weighed in on this issue publicly. This is on their website right now. Seat belts are the single most effective traffic safety device in vehicles today. We talked about airbags as being the new panacea that was going to solve all of our problems. Now, we've had airbags in vehicles now for 20 years, and we know seat belts make a huge difference. Airbags help. They're worth having, but seat belts are the best occupant protection device within the vehicle. And as we talked about earlier, even over a longer span of time, 2/3 of the fatalities in the state of Montana are attributed to seatbelt non-usage. And even if we're not looking at fatalities, we're looking at injuries. The risk of a moderate or severe injury is cut in half if somebody is wearing their seatbelt. But you don't necessarily have to take just the Montana point of view on it. Pick your favorite source of information. They're all pretty similar. Nationally, the Centers for Disease Control have very similar pronouncements. Seatbelts are the most effective way to prevent death and serious injury in crashes. And I find it really compelling, the disparity between the low proportion of people who are not wearing their seat belts and the high proportion of those unbelted occupants that end up in a very severely injured condition at the end of a wreck. So let's go to the libertarian perspective that it's my choice, it's not the government's, it's my car, it's my decision. I ought not to be subject to that sort of bureaucratic requirement. Well, okay, let's take a look at what your choice then implies. First off, we touched on this earlier. Here's a big shocker. If somebody is not wearing their seatbelt and they're in a car crash, the hospital bills and the medical expenses that get rung up as a result of that person's experience are much, much higher, about 3 times higher compared to a similar sort of crash with a belted occupant. So the costs are much, much greater. And who bears the cost? This comes off the official Montana state government website, a page for the Department of Public Health, that lack of seatbelt use is costing all Montanans a lot of money. Montana spends $14 million on Medicaid and uncompensated care for unrestrained injured occupants, and their own sources of insurance and other resources only cover about 26% of the cost. So let me ask you, who's paying the rest? Who's picking up the tab for the 75% of those increased costs? That's right, all of you who pay insurance, all of you who pay health insurance costs, all of you who pay your taxes. This is imposing costs on all of us. This is not a personal individual issue. This is a statewide policy issue because it does have such far-reaching ramifications. Well, now I'll turn to the last point. You're blaming the victim. You know, if somebody has the unfortunate circumstance to be in a car crash, you know, boy, we should give them the benefit of the doubt, and we shouldn't criticize them for not wearing their seatbelt. That's just not fair to the poor person. Well, this is sort of interesting. What I think that is saying is that you don't trust the jury to learn the full facts of the accident, that we don't trust people to allocate fault according to the facts of each individual case. I don't think that's right. I think that dishonors jury service, and I don't think it's fair to the people who sit on juries to have critical evidence hidden from their view. The Texas Supreme Court looked at this issue not long ago. Texas enacted a repeal, but it had to go through the courts before it ultimately became effective. And they spoke to the issue about whether you're really blaming the victim. What they were really, and how they decided the issue is, this is not about giving somebody a benefit over somebody else. This is about telling the truth and letting the chips fall where they may. There may be some accidents, maybe a low-speed rear impact, where seatbelt use wouldn't have made a difference to the outcome. That's what juries are for. There may be some accidents, like our friend Bob that we looked at in the expedition, where seatbelt use made all the difference. Let's let the jury learn those facts. Let's trust them to give us an outcome that makes sense under the laws and under the values of the state of Montana. That's what this kind of reform would be all about. Now, you may be asking yourself, well, if this is such a great idea, why are you here in Montana talking about the issue as opposed to some of the other states? Well, a number of other states have started to move away from this 1980s model. At least 11 states so far allow unlimited introduction and consideration of seatbelt non-usage evidence. One of the more recent states to enact this reform is Oklahoma, and you can see how they structured that statute in Oklahoma when they enacted that a few years ago, making it explicit that seatbelt non-usage evidence would be considered. So that's the sort of reform that could be considered in Montana. And I would note this, if anyone is serious about this sort of an issue. Senator Fitzpatrick's bill from last session was a valiant effort and a great foundation building step in raising the visibility of this issue and getting things under discussion. However, his bill was a pure repeal, and that makes, you would think that would make sense and that would be a good way to approach it. Actually, Texas went that way as well way back when. The problem was that when the gag rule was wiped off the books, then what was left were the pre-gag rule ancient history cases back in common law in the 60s and 70s. And what the court said in Texas and what the Montana Supreme Court said in that era were, because of the harsh contributory negligence rule and some of those other circumstances, we're not going to let juries consider seatbelt non-usage. So in order for the statute to be effective, you got to take those cases into account. And so instead of just a wipe it off the books repeal, it would need to be some sort of an affirmative statement that this is admissible, it is no longer inadmissible. And in Texas, it took them about 10 years after they enacted their repeal to get the cases to go all the way to the Supreme Court to actually get the effect turned around. So that's my discussion of a concrete, practical issue. I hope it is something that captures your attention as a pathway that could help move Montana up the rungs on the ILR ranking. It is something, as I said, that has major repercussions for business, for insurance premium payers, for taxpayers as a whole, and I think it would do Montana a lot of good. Be happy to answer any questions anyone might have.
Lee, quick question to start us off. My vehicle, my wife's vehicle, starts to chime incessantly as soon as we pull out of the driveway, and I suspect that's going to be more and more the norm as vehicles are more modernized. Will this issue begin to kind of take care of itself as old vehicles are transitioned off the road and that's more a standard?
I wish that were the case. The chime system that you describe has been supplemented by things like there's a technology in Ford vehicles that's been rolled out called My Ford, where if the teenager is using the teenager key, then the radio won't work if they're not belted. All kinds of reminder systems have been tried for a long, long time, but yet we don't have universal usage of seatbelt systems. And ultimately, that's the only way that this problem is going to take care of itself is if everybody wears their seatbelts. I don't think that's likely in the future. Montana's rates have been hovering around 75% for 5 or 8 years. It lags the national average by 12 to 15 points consistently. And it is those people, it is the unbelted people that have the more severe injuries, and it is the more severe injuries that are more likely to sue. So I think it is a circumstance that's around for the foreseeable future, unfortunately.
Other questions for Lee?
Well, I think the Montana Chamber should do something to make sure that this presentation is mandatory for anybody who's running for the legislature before our next legislative session. I think you did an excellent job. I just think it was very well presented, and the legislators and the future legislators need to have this information.
Well, thank you so much, and I'd be happy to come and lean on them all.
I'm sure you will. Additional over here.
For those states that have enacted these sorts of statutes, is there any good insurance premium data out there that would support the argument on cost reduction?
That's a really interesting thought. The answer is there have been efforts made to chase that down. The problem is that insurance rates get affected by so many different variables, it's hard to pinpoint any one particular thing. I will say this, just about 2 weeks ago as I was putting together my slides for this presentation, I saw a news report on insurance premium increases that have happened over the period 2011 through current. Over that period, Montana leads the country. No other state has seen a greater insurance premium increase than this state, 64% over that period. Most of the, and again, it's very difficult to tie one to the other, but I will say that most of the states that are on my list of reformers fall much lower on that ranking. So, and unfortunately, it's difficult to tease that kind of data out and with that level.
Any final questions here?
So I've got a comment, and I am the Buckle Up Montana coordinator for the Tri-County area, Lewis and Clark, Jefferson, Broadwater counties, with a couple of my friends here, Sergeant Spencer and Captain Collins with the Highway Patrol. This is obviously of great interest to us. We have a working group that meets once a month. If anyone's interested, we're the Occupant Protection Emphasis Area Working Group through the Montana Department of Transportation coordinates that, and we're always looking for new members. But I could also foresee maybe this group being the group that leads a charge for a primary seatbelt law. We've tried it every session, and it's usually the same group of law enforcement and advocates. But this may be a group who can help with that work and drive that forward. So if anyone's interested, we meet once a month, and we'd love to have some new faces at the table for that reason.
Well, bless you for the work that you're doing, and there's an interesting parallel between this reform on the civil side and the primary enforcement switch on the criminal or enforcement side. And I'm sure I'm not revealing anything new to you, but in states that have gone from secondary enforcement to primary enforcement, use rates go up quite a bit. And toward your point of, will this problem, to some extent at least solve itself? Well, that would be a step in the right direction. And I guess the way, as I have weighed this issue and tried to balance all of the different pieces, it has always struck me that a joint effort of moving to primary enforcement and then also moving to admissibility makes a lot of sense. They are two directional movements to encourage people to wear their seatbelts and think about it and take it seriously. I don't see anything inconsistent with both of those approaches going in tandem. But thank you.
Time for one more here. Actually, we got a few folks, don't we? I think we can get two more in here.
Great presentation, and to echo the previous speaker, we have tried for as long as I've been up here in the legislature for decades to pass a primary. How do you answer the question, and have you run across that? Because we would seem like we would pass the Senate and then we'd get over in the House and they would come up with, well, we're worried that they'll look into our car, they'll start using them to tail us, to use if it's a primary as a way to go after folks, and which we have no evidence to show that's the case. But how do you respond, and is there a way you can do that?
So I gather the question is about on primary enforcement. How do you respond to the argument that it would be used for profiling or for harassing individuals? And I guess I would look to the other states' experience. That has been a concern all along. And in other states that have enacted it, I don't remember off the top of my head, it's something on the order of 35 states that have enacted primary, might be more than that at this point. I am aware of no evidence from any other state that it has been used to harass or to profile. And in fact, because the issue has been raised as much as it is, the concern has been raised as much as it is, I think what you would hear from law enforcement, what I have heard from law enforcement is, to the contrary. They are going to enforce this across the board. It is a public safety issue. It is not some sort of a tool for maliciousness. And I guess I would also come back to, my theme was trust the juries. I think the other thing to bear in mind when we consider a shift to a primary is, do we trust our law enforcement officers? If we trust our law enforcement officers to do their job on an everyday basis and to not harass people for profiling reasons or any other reasons, then why would we not trust our law enforcement officers with this new tool? If we didn't trust our law enforcement officers, the old saws about, they can always find a way to pull you over, I suspect that would probably be true. If they wanted to, they could. That's not what we see, so why would we believe that? That's how I would respond.
Got one last question right here, Lee.
I just have a brief comment. My name is Lauren Jarrell. I'm with the American Tort Reform Association, and this is an issue that is very important to us. I will actually be talking about it a little bit more this afternoon. And we work really closely with Lee. He does a terrific job for us at the state level. And so this is something we are certainly interested in working with the Montana Chamber on. We've partnered with other states this year, Kansas and Missouri. And so I just wanted to sort of let you know that we are available for support, and we'll be talking about it more this afternoon.
Thank you so much, everyone.